Okay, so this is going to be a brief guide to defamation law and some related subjects for YouTube commentators, because that's quite a common thing now, where people are doing YouTube and they are commenting about other people. But obviously there is a defamation risk. So what I want to do is give a sort of brief practical overview. Don't want to get too legalistic, but just explain some of the issues that you need to be aware of. So the first thing is, what is defamation? Well, defamation is an untrue statement about somebody that lowers their reputation in the minds of right-minded people. We use all sorts of tests. Sometimes we talk about it's something that causes people to shun and avoid you, to use the old one. Now, we hear about libel and slander. So what's the difference there? Some people say libel is written and slander is spoken. That's not quite true. It's actually, libel is permanent and slander is transient. So if you are making a YouTube video or something on social media, obviously that's not written, that's just spoken. But because it's there forever, then that counts as libel. Whereas something like Twitter, that's very, very fast moving, even though it's in writing, because it's, the courts recognise that it's a conversational thing. People post things, people reply, and then people move on. That's treated more akin to slander. Although for reasons we'll come on to, that difference doesn't really make a lot of, that distinction doesn't make a lot of difference in practical terms now. There's also something called malicious falsehood. The thing with malicious falsehood is that's an untrue statement that is calculated to cause somebody loss. But it doesn't have to be a defamatory statement. So say, for instance, somebody asks you, could you give us Bob's phone number because I want to employ him for a particular job? And you say, well, actually, Bob's not available now because he's out doing charity work and he's devoted himself to that. Well, obviously, there's nothing defamatory about saying somebody does charity work, but that's a false statement. And if that person then goes, oh, okay, then, well, I won't hire them for the job, that person has suffered a loss. So that's malicious falsehood. Who can sue? Well, any person can sue, and that includes natural persons, humans, but also legal persons, such as corporations or companies or organisations. The main difference there is that obviously a person can claim damages for hurt feelings, whereas a company can't have feelings to be hurt, but it can claim for reputational damage. But now that's, generally speaking, that has to be a financial loss. Because we now have something called a serious harm test. And this is why the libel slander thing doesn't really count anymore. In the olden days, before 2013, libel was deemed to be defamatory per se. In other words, you didn't actually have to show that you'd suffered an actual loss. You just had to show that there was a statement that would lower your reputation, and the courts assumed that you would suffer a loss because of that. Whereas with slander, you had to actually identify a specific loss and say, this is a loss I have suffered because of that. With a couple of exceptions, disparaging somebody in their trade, calling, or professional was always deemed to cause a loss. There's also the imputation as to the chastity of women, suggesting women weren't all pure and virtuous. That was automatically slanderous. I actually did one of the last cases where that was a feature, but that's all gone now. Also, having certain communicable diseases. All the old Victorian ones, like sort of TB or consumptions, would have said, because it's the shun and avoiding thing. But now, because you have to show a serious harm element in libel, like the distinction's gone there. And you have to actually evidence the serious harm, with a couple of exceptions that I will come on to, because they're going to be quite important for YouTubers. It's not just enough to say, oh, come on, you can just infer that this will cause me harm. You actually have to say, either here's some harm I have definitely suffered, or here's some evidence showing why there will be a tendency to cause me harm. If it's a corporation, or a business, then that has to be serious financial harm. If it's a human person, then it doesn't necessarily have to be financial. It could be things like, injurious reputation, people are avoiding them, they've lost friends, all that sort of thing. Now, when it comes to allegations of criminality, however, if you make an allegation that somebody has committed an offence that can attract a sentence of 12 months or more, the courts tend to say, well, that is actually proof that somebody will suffer serious harm. Now, in defamation, when it comes to allegations of criminality, we talk about chase levels, although it's more of a spectrum. But chase level 1 is, this person definitely did it. Chase level 2 is, there are strong grounds for believing that this person did it. And chase level 3 is, there are grounds for investigating whether this person actually did it. But like I say, that's more of a spectrum. I mean, sometimes we get into arguments and go, oh, this is like chase level 1.5 or 1.5. But that's the sliding scale. Now, obviously, in terms of, and we'll come on to sort of the defences, but an allegation that somebody has definitely done something is more serious than suggesting that there's grounds to investigate whether somebody has done something. But also, it tends to be easier to prove, to show, well, look, here's my reasons for saying there are grounds for investigating, or here's my reasons for saying there are grounds for suspecting. I'm not saying they definitely did it, but here's some evidence to suggest why they might have done it, as opposed to a blanket statement saying, yes, they definitely did it. Now, when it comes to defamation, you can't cherry pick individual things. You have to take the statement into account as a whole. And when I say statement, obviously normally that would be words. You'd either write or speak, but you can defame by actions. There was a famous case where somebody was acquitted of a murder, but Madame Tussauds put his waxwork in the Chamber of Horrors next to loads of acknowledged and convicted murderers, and he was able to successfully sue on the grounds that just by putting his waxwork there, that was implying that he was in fact guilty. In defamation, we talk about bane and antidote. So that means something that at first blush seems defamatory. I mean, the classic example is newspaper headlines. If, when you read the full story, that puts a different slant on it and it's not quite as bad as the headline may have suggested, the courts say you have to take that as a whole. You have to take that all into account. You can't sort of say, well, this headline's really defamatory, if somebody could read the rest of the story and get the full background. Now, that originally, like I say, applied to newspaper headlines, but it could be the same now with thumbnails. You might put a title on a video. I mean, I suppose one example, Gary Oldman is a terrorist in the fantastic film Air Force One. That's the bane and antidote idea. So if you put a headline that was at first blush defamatory, but then when somebody actually watched your video and saw the background, they see that perhaps you were being a bit hyperbolic or exaggerating, that could amount to a defence. But what are the general defences to defamation? The classic example is truth. It's a total defence to a defamation claim to show that what you said was true, or indeed substantially true. You don't have to get everything right if it's the case that the bits you didn't get right wouldn't make much of a difference. So, if you say, aha, this person is he's a bank robber and he robbed Barclays, the mere fact they can come and say, aha, it wasn't Barclays, it was NatWest. Well, you'd probably succeed there because it's substantially true. There's also the defence of opinion, because a defamatory statement has to be a statement of fact, not a statement of opinion. However, the mere fact you say something is an opinion, if it is in fact a statement of fact, in my opinion, such and such person is a creep, or is a predator, or something like that. Well, actually, you're alleging that as a statement of fact. So for the defence of opinion to succeed, first of all, it has to actually be an opinion, not a statement of fact. It has to be based on facts, and you have to allude to the facts that you're basing your opinion on. And this is something I'll come on to, that it's always very important to link, if you're commenting on something, link to the evidence, link to why you are saying this. You'd have to give chapter and verse, but you would have to say something like, if you're saying such and such person is an abuser, that's a statement of fact. If you say, in my opinion, such and such person is an abuser because here's some facts about their behaviour, and in my opinion, that amounts to an abuse. It has to be an opinion that a reasonable person could come to based on those facts. It doesn't have to be an opinion that everybody would agree with, but it has to be an opinion that a reasonable person could come to on those facts. And it actually has to be an opinion you honestly hold. I mean, usually that's not really an issue in defamation proceedings, but that is actually part of it. So the mere fact that you express something as an opinion and you meet all the tests, if actually you don't really hold that opinion, you're just doing it to, have a go at somebody or harass them, then opinion would fail. It's also a defence to say that what you're commenting on is in the public interest. But it's a two-part test, and a lot of people get this wrong. The first part of the test is it has to be a subject that is in the public interest to discuss. So that could be somebody's bad behaviour. If somebody is out there doing something like nefarious, then, arguably it's very much in the public interest that this topic should be discussed. But the second limb of public interest is it has to be in the public interest in the way that you did the disclosure, the way you commented. So if you just sort of release the information out there, then arguably the way you did it is in the public interest. So, you can do things like, if however you were to give them a right of reply, or if you were to seek comments, and you see, then this is why you'll always see in newspapers, we approached so-and-so for comment, but they didn't get back to us. As long as you've given them a chance to comment, then that can actually assist you with your public interest defence. But you have to be careful, because it could be, something like, well, if these allegations are that serious, you should have reported them to the requisite authorities, and that is how you should have actually addressed this thing. But yeah, like I say, in both opinion and public interest, the key thing is to refer to the facts. Now, the way defamation works is that judges, and indeed lawyers, we are told, don't think like lawyers, don't overanalyse this. Just look at it. What would the average hypothetical reader that is neither unduly naive nor unduly prone to scandal and gossip, what would they think just like observing this or reading this or watching the video at first instance before all the lawyers start arguing about what it means? And judges will actually approach cases like that. When you get to defamation proceedings, the claimant will argue, what the words mean. The defendant will argue that they mean something totally different, but judges will just actually look at it once without even looking at what the lawyers have actually argued. The first thing judges do is either read the article or watch the video and go, well, at first blush, what do I think this actually means? Because now that, when we used to have juries, it was up to the jury to decide what the words meant. Now this is dealt with actually by the judge. So the first thing we do is have a meaning hearing, and the judge says, what does this statement actually mean? Now it's irrelevant what the claimant argues it means or what the defendant argues it means, because the claimants always argue that it's something very serious. Oh, this is an allegation that I've engaged in massive criminality and a cover-up and I'm the worst person in the world. And the defence will argue, no, it's not. It's just an allegation that you were slightly dodgy and it's just, clearly an opinion. The judge says, I don't care what you say and I don't care what you say. What do I think it means? We have what we call the single meaning rule. Now, most defamation practitioners will agree that this is probably the daftest rule in defamation. And the courts themselves have said if we started defamation from scratch, we wouldn't introduce this rule. But the rule is, it doesn't matter if there are multiple meanings, some of which are defamatory and some of which are not. The judge has to go, what's the one meaning that most people will think it says? So it's not a defence to say, well, actually, a load of people would think it was the non-defamatory meaning. The judge can say, yeah, but more people would think it's the defamatory meaning. That's a different test to malicious falsehood, by the way. In malicious falsehood, if you can show there is an innocent meaning to your word, then that is a defence itself. What about commenting on court proceedings? That's another defence. You are allowed to make fair and accurate comment on court proceedings. Now, if those court proceedings are ongoing, you can actually report, even though it's going to be quite one-sided, because say it's a criminal trial, then initially you're just hearing the prosecution case, aren't you, and the prosecution witnesses. But you can report on that and say, well, in court today, the prosecution witnesses said this, that, and this about this person. And that's not defamatory, even though we haven't had the full trial yet, and the defence might have something to say and that person might be acquitted. Although to cover yourself, make it very clear that you are commenting on a trial that is part heard. You know, that's not the conclusive proof. So the mere fact the prosecution witnesses have alleged something, and again, you'll see this in newspapers, it'll say something like, Mr. X denies the offence, the case continues. And that's all you need to do. If, however, you're commenting on legal proceedings after a trial, then you have to give the full balance, the full story. You can't just pick and choose and say, in this trial it was alleged that, you know, this happened and this happened and this happened. You would have to report and say, however, the defence argued this, this and this, and ultimately the person was acquitted. You know, like I say, it's this, you can't sort of cherry pick. Also, though, when you're commenting on ongoing legal proceedings, be very, very careful about contempt. It's contempt of court to publish any statement that may interfere with the course of justice by prejudicing a jury, for instance. So, you know, you can't be very careful. Don't refer to things that the jury might not know. Don't refer to people's background. Actually, this person's already got convictions for this. I mean, it might well be that the jury are told about those convictions, but you have to be very, very careful, because it might be information that isn't put before the jury. And although judges give jurors warnings and say, look, just try this case on the evidence before you and not anything you've read about in newspapers or seen online or heard down the pub. That's something I'd be very careful of. And contempt proceedings start from whether a trial is actually happening, but they also start from whenever proceedings may be contemplated. So it can actually, you can actually commit contempt before actually anybody's even been charged with an offence, even if it's like, well, it looks like they are going to be charged with this offence. So be very, very careful there. What about if you don't actually identify the person? You just comment, say, you know, my ex did this, that, and the other. Well, then you get into, like, would anybody know who you were talking about? Now, you could argue and say, well, most people wouldn't know who I was talking about. However, if there is a subset of people who, without any further evidence, would know who you were talking about, then that's, you know, can be defamatory. Because yes, well, these people actually did. Most people wouldn't have known you were talking about, but these people did. So you've actually made the statement that is defamatory, would cause these people to think less of somebody. I mean, it's not all, it can sometimes be a defence to say the only people who have heard this actually already had very fixed opinions and it wouldn't change anybody's mind. But you've got to be very careful running that argument, because the whole point is you are putting something out there that will affect somebody's reputation. The other thing to remember is defamation is about reputation, not character. It's what people think of somebody, not what they're really like. And there are some people who are actually pretty much defamation proof, because their reputation is so poor already that the argument is anything you say about them couldn't actually lower their opinion any further, because everybody already thinks there's something highly suspect about them. If, however, somebody had to do some research to find out who this person was, it's like, well, this person's saying they're their ex, I can go and I can do a little bit of background and search their social media and work out who it is, then actually that wouldn't count, because, like I say, the thing to do with defamation is it's all about first instance, it's all about what first impressions. What does somebody get just from reading your statement or watching your video? But that does include taking into account things like if you post links to things and say, for more details, see this link. This is what I'm basing my opinion on. This is why I'm saying it's in the public interest. If you actually post the link, then the courts will usually deem that people will read that. But you've got to be careful with things like Twitter, for instance, because you might be replying to a comment, but you're replying in isolation. People just read that and don't know the background. So that's why, maybe like quote tweets or link to what you're doing or screenshot what you're commenting on. And that's the same for when you're actually doing, like videos. Now, also we talk about SLAPs. That's strategic litigation against public participation. That's where somebody uses legal proceedings or the threat of legal proceedings to shut somebody up and just not comment. we are shifting now towards recognising slaps. And you can sometimes get a case what we call struck out. So somebody can bring a claim, you say, well, actually, this is just a slap. They're not bringing this to protect their reputation or for legitimate reasons. They just don't want people commenting about that. And the test courts apply there is they will look at, first of all, what the reasonableness of your position, but they'll look at what's the tone of the correspondence? Have people made it clear that they've been overly threatening? If you publish this, I'll sue you and I'll have your house and I'll do all this sort of thing. Now, don't get me wrong, you can actually, say, look, if you don't take this down or if you do sort of say this, then, I will sue you. You're perfectly entitled to do that. I mean, one thing in defamation, though, is you can't get an injunction to stop somebody publishing something prior to the trial, except in very, very rare circumstances where it's clear there literally would be no defence. But if somebody says, no, I'm going to defend myself in court, we have the idea of, it's called no prior restraint, publish and be damned. I mean, after a trial, if it's found to be defamatory, then the courts can make injunctions saying you must not repeat this ever. But nobody can actually, if somebody says, I'm going to rush off to court and get an injunction to stop you saying this, a cease and desist or anything like that, generally speaking, the courts will not grant such injunctions. But what about the actual process? How do you head these off? Well, defamation proceedings don't come out of the blue. The first thing, we have what we call a pre-action protocol for defamation, and that's a series of steps people have to do before they initiate proceedings. So the first thing you have to do is they send a letter before action. And the letter before action sets out what they say the defamatory statement is, what they say that means, what serious harm that has caused them, and what remedy they want. And then you have to respond to that. And that's where effectively, if you have a defence, that's when you will first set out your defence. This is before proceedings have either started. You might say, well, we say this is true, and we say this is an opinion, we say this is in the public interest to discuss. Because you have to be very careful about this. Let's say you say, well, actually this is true, lots of people have said this about the person. Well, yeah, but if this goes to trial, will they be willing to come and give evidence and say that in court? Because, a lot of people, court proceedings are very traumatic. And a lot of people just don't want to get involved and don't want to have all that exposure. I mean, we talk about, the Streisand effect. That's when claimants sue to shut somebody up, and then because of the court case, there's more publicity, and that just highlights what they were trying to hide. But also, it's horrible being a witness in any case because, people ask you questions, and some of those questions may be actually embarrassing. Also, let's say you actually go, do you know what, I've messed up there. I don't have a defence to this. Well, you can actually deal with things before cases are issued. You can do what we call an offer of amends, where you say, okay, hands up, I got that wrong. What I'll do is I'll publish an apology, I'll retract the statement, all that sort of thing. But the trouble there is you're still on the hook for damages. It massively reduces the damages, the fact that you have been willing to put this right. The damages used to be capped at £10,000. There actually isn't a cap anymore, but the fact that you have apologised and put things right obviously does lower the damages. The flip side of that is, although we don't have punitive damages in this country, we do have what we call aggravated damages. So if you stick to your guns and say, no, I insist this is right, I'm going to repeat the allegations and I'm going to have a real go at you in court and I'm going to highlight all your bad stuff, and then you lose, the fact that you were doubling down on that can actually increase the damages. And the trouble with like defamation damages is they can be a lot. Certain things are very serious. Allegations of the P word. If you accuse somebody of the P word, then you're looking at 80k damages. And also, defamation proceedings are hideously expensive in terms of legal costs. You've got to instruct your own legal team, unless you want to fight it yourself. But the rule in this country is loser pays winner's costs. So if you are sued and you are unsuccessful in defending that case, then you have to pay the other side's legal costs as well. The flip side is, if somebody brings a claim and that claim fails, then they have to pay your legal costs. But that's sort of like a very, very brief overview. I mean, as always, the devil is in the detail. But I hope I've highlighted some things that, you might find useful there. And if there's a demand for more detail, please feel free to let me in the comments. But anyway, as always, hope you found that vaguely interesting, vaguely useful, vaguely accurate, and I'll see you next time from somewhere a bit warmer than this cliff top.